Okay, so today we're going to get caught up a little bit. Sorry about missing class last week. My daughter actually tested positive last Tuesday, I think it was, afternoon. But I tested negative, so I'm good. I just wanted to be sure. It took me forever to find a test. Wow. Okay, so I'm going to start off with this slide here. And I just want to go through this a little bit and talk about the relationships that I kind of break it down into three areas that are where international law comes into play, both historically and then as we have moved into post-World War I and post-World War II. Some changes have really taken place due to those wars and the events leading up to the wars and what happened during those wars, and then what occurred in terms of development in international law post-World War II. So I want to start with this first one here. Historically, international law only dealt with the relationship between states, that is, sovereigns, and how they interacted with each other. And any issues that were within the borders or boundaries of a state were considered to be domestic and not within the jurisdiction or the realm, if you will, of international law. Now, part of that is just a practical matter, and the idea that one state versus another state, you have two sovereigns. And this is the idea that what takes place within a sovereign state is really up to how the sovereign government, whatever the type of government that may be, whatever laws they enact within their particular state, how they treat their people that are within the state is considered a domestic matter and not within the realm of international law. Now, this is kind of historically. And the idea of that primarily is that if you're sovereign, you control your territory. That's the whole definition of sovereignty. And if another sovereign or a group of sovereigns can essentially tell you what to do within your own boundaries, within your own borders, then you're not really sovereign to begin with. You're something other than sovereign. And so part of that also had to do with the idea, which I've already talked about a little bit, the idea that if a sovereign enacts law within their own state and another sovereign doesn't like that type of law or what's going on within that state, historically, really the other sovereign didn't have a lot of options. And so they could, if they don't like what's going on within a state, they could use military force or economic force, page 13, or other type of force. So let me just give you an example. I talked about this last time. So if we have these 5 states here, and let's say again state E, a sovereign state, has laws that discriminate against a group of people, perhaps based upon their race, their ethnicity, their religious orientation, their cultural orientation, or whatever, and these other states don't like those laws and how they treat their people. You know, maybe they have a group of people that live within this area of that state, and they treat those people in a bad way. And these other states don't like it. So historically, what were their options? Well, under international law, just as a matter of practicality, what happened within the borders of this state domestically really was, to put it bluntly, none of the business of these other states. If they didn't like what was going on, in theory, they could use military force to go in and overthrow this government to protect this group of people. But the likelihood of that occurring was pretty rare unless there was a connection, you know, culturally or religiously or whatever, with this group of people and these other states, or perhaps one of the states or whatever. It was just as a practical matter. The idea being, historically, what happened domestically was purely considered to be domestic law and not within the realm of international law. Now, that has changed. And a lot of that, again, flowed out of, well, even before World War I, slavery, and then going into World War I, and then World War II, of course, with Nazi Germany and all the other things that happened during World War II. The idea being that, hey, wait a minute, it's not really right for international law to always ignore what goes on domestically within a state in certain circumstances. And the idea being that international law should not just involve relations between sovereigns, but at some level there should be a mechanism, an organization, or other means for the international community as a whole to have some, how do I put this, say or input or authority or even, if necessary, economic or military force to act collectively in the event that a state is behaving in a certain way against people within the borders of that state. So, back to this slide here, historically, international law only concerned the interaction between states. That has essentially changed now. So now, if we look at things, one type of relationship internationally is how do states interact with each other. And that's clearly still within the realm of international law. Treaty making, conventions, and intergovernmental organizations, non-governmental organizations that cross international boundaries, international trade, that's still clearly all part of international law as a whole. But we have seen this development, if you will, to now we also have international law that involves these other two relationships that really historically was not part of international law. So this next type of relationship is the idea of in a situation involving a state and a person. Now when I use the word person here, I'm referring to a broader term. That term meaning an individual human, like all of us, or a private entity, like a company or multinational enterprise corporation or other type of entity. In other words, a non-state entity of some type, either a human or a fictitious legal entity such as a corporation. We call that a juridical entity, which I'll get into that later. So historically, and I talked about this last time with my little example here, if we have a ship that is seized by this state, E, and that ship is from country A, historically this individual owner of the ship did not have any recourse directly against another country. And that again had to do primarily with practical matters, because if the individual that owned the ship wanted to take action against state E, essentially they had to go to their own government A and see if their own government would do something. And whether or not that would occur was up to the government A. There were no structures in place for an individual to take direct action against country E. Now when I say direct action, what do I mean by that? A lawsuit, for example, all right? So country E seizes a ship and the cargo imprisons the crew. The individual owner did not have any mechanism to take legal action against country E themselves. Now they could file a lawsuit in a court in country A, right? A judge in country A may very well say, well, country E, what you did is wrong, and issue what's called a judgment, that is a decision by the judge that country E has to return the ship. But the sovereign in country E may just say, well, I don't recognize your courts, I don't recognize your judges. Too bad. I'm not going to basically do what you're telling me to do. And there was really no mechanism there. Again, remember, rule of law versus rule of force. So the idea of rule of law, as it applies to this second relationship that we're talking about, is to put in place, in certain circumstances, this is not always the case still today, but to put in place mechanisms whereby an individual that has some sort of claim against a foreign government to be able to take direct action against that government without having to have, or at least only needing partial involvement of their own government. So for example, we now have in certain situations where a country has taken property, it's called expropriation, which we'll get into later in the term, but the idea is that if a foreign government has seized property of an individual from another state or caused harm to them, either physical harm or economic harm, there are now structures in place, usually it's through international arbitration or international judicial, that is court activity, whereby an individual can essentially sue the foreign government themselves. Now sometimes they have to get permission from their own state to do so. Oftentimes it will still require the country that is being sued to agree to be held under the jurisdiction of that tribunal, whatever it may be. In other words, they have to consent to it. But the idea now is the ability of an individual, if they have been harmed, to be able to take direct action either through the court system, through an arbitration, through the World Bank, or through other mechanisms. And we'll look into some of those more later on. We still have, however, this overriding historical idea that international law is primarily involving state versus state claims. Later on, we're going to talk about what's called the active state doctrine, and we're going to talk about immunity, international immunity of states, sovereign immunity it's called, and that's where essentially a state is immune, including diplomats, diplomatic immunity, you've probably heard of that, where a state cannot be sued unless the type of case involves certain circumstances or the state has agreed to it. So let me give you some examples of what I'm talking about. A treaty or a large convention whereby you have maybe 100 different states that have signed on to the convention. Convention is a large treaty. And so as part of being involved in that convention, the states have to agree, if there is a dispute involving other states or people from other states, they have to agree to the jurisdiction of a court within that state. And if a court in state A makes a decision as part of that treaty, that decision by the court in country A can be filed and applied in country E. They agree to it ahead of time, basically. They consent to it. Now again, why would they do that? As we've talked about, it benefits them. They want to uphold rule of law versus rule of force and various other reasons. So as we get through the course, we'll look at this idea of state versus person claims. Sometimes you'll see newspaper articles about a court has agreed that an individual that was harmed by a foreign government can go ahead and file a court case. And that's usually a judge has to make that decision. And again, we'll talk about that more later on. And then finally, we have this idea of person versus person in international law. And I've talked about this already a little bit. I'm not going to spend much time on it, but basically the idea is If we have individuals from different states that have claims against each other, maybe a breach of contract claim or a personal injury claim due to an injury caused by a person from another country, that there's the ability to take direct action in an international forum, so they can sue the other person or the other company directly. So for example, if we have, let's say, a person in country A or a company that enters into a contract with a company from country D, and they get into a dispute, we have, again, now treaties that have been put into place whereby the courts in country A and country D agree to recognize the decisions of the court of each other's countries. So if I sue the company that's from country D in a court in country A, and I win, I can file that judgment in the courts of country D and then take action to collect, maybe seize the bank accounts or the other assets of the party that's in breach of contract. I can sue in my country and then take action in the other country to collect upon my lawsuit, where traditionally we just didn't have that. And that's been a big part, especially in international business law, the ability to do that kind of thing. Now typically that ability will be part, again, of a treaty, or it may be part of a large convention or an international organization like the World Trade Organization or some other format like that. Or it may be part of a United Nations, like for example, we have United Nations trade law, which are treaties that involve various countries that allow for the people of the different countries to take direct action in either arbitration, and there are rules that the United Nations have created for international arbitration. Arbitration is where a third party acts like a judge. And then the arbitrator's decision can be filed in both countries, and you can go collect on those cases. And again, we'll talk more about that later on. But I just want you to be aware of these three basic relationships, because I'll be talking about them over and over. State versus state, again, historically, that was the realm. And the idea of getting to rule of law is to put together organizations such as the International Court of Justice, the World Trade Organization, where states may take legal action against each other without resorting to force. State versus person, where a person may have direct action against a foreign state in some cases, not always. And then finally, where people of different countries can take direct action against each other depending on the type of case. All right, now somebody sent me an email about the essay questions. I'm still working on those. I'll try and get them posted by next week. I had them all ready to go on Moodle, and then when it converted to Canvas, something went haywire, so I got to fix that. But I do have an essay question where basically I want you to kind of explore how historically these three relationships have changed, and what the role of international organizations are, especially the UN, the European Union, World Trade Organization, and international arbitration, how that kind of impacts this. And I'll give you examples of it throughout the term. All right. Page 14. I can't remember if I talked about this slide or not, but just real quickly. Why is this not working? Okay, public international law versus private international law. When I use the term public international law, I'm referring primarily to international law that deals with how states interact with each other. large scale. So this will be the United Nations, the World Trade Organization, international treaties and conventions, international law on how force can be applied or not applied, when force is legal or not, in terms of self-defense or other type of force, collective use of force. Conventions and IGO. An IGO is an intergovernmental organization, such as the United Nations. And we'll get into those here over the course of the next few class days. Constitutional law, which is essentially law either domestically or like the UN Charter, that is international law that deals with how international organizations are structured, what rights and duties they have. Like the United Nations essentially has almost the same level as a state in terms of international immunities and other type of activities. The European Union is based upon a number of different treaties within the European Union member states, and how those type of treaties interact with each other, falls under public international law. And then we have private international law. This is the law that governs the relationship between individuals among various different states. That would be contract law, international contracts, international law involving family, like for example, international custody. If you have a cross-border custody dispute the parents are involved with, we have international treaties involving that. International law involving wills and estates, that is, how wills are written, so after a person dies, if they own property in various different countries, whether the will that's written in Oregon will be valid in France or whatever. We have international law on that, and other type of what we call private international law. And again, this goes back to kind of those three relationships. Public international law is state versus state and persons versus state. And then private international law is the law that governs the relationship among individuals at a smaller level, right? People from different countries. Okay, I want to show you on page 15, there's my highlighter here. All right. So, this slide is Article 6, Clause 2 of the United States Constitution. This is called the Supremacy Clause. And this part of the U.S. Constitution is where we have a couple of different ideas coming out of this paragraph. The first idea is the idea that federal law, and we're talking domestically within the United States now, federal law, that is law made by the United States government, Congress, and all other laws made by the federal government domestically within the U.S. will be the highest level law that we have domestically. And so that means that a federal law will override a law from the state of Oregon. We also have, however, these four words right here, and all treaties made. So the Constitution of the United States, highest level law we have in the U.S., of course, and the laws of the United States, which Congress, which would be statutory law, and all treaties made shall be the supreme law of the land, and judges in every state shall be bound thereby. Now, I want to show you that because it's very important when we talk about how international law applies within the United States. And we see the same concept in other countries as well. The European Union is based upon this same idea, the idea of European Union law being supreme over the law of the various different member states. And so this is the idea, the concept that a treaty, which is an international agreement, will override law that is domestic. So an international treaty will override domestic law. And we're going to see this idea kind of over and over again, but I'll just give you, the World Trade Organization is another example whereby the World Trade Organization is based upon a large international agreement. I want to say 159 countries, more or less, are part of the World Trade Organization. And as part of that, the WTO rules, all of the member countries have agreed that if their domestic law conflicts with a WTO rule, the WTO rule will override the domestic law, and then the country will have to change their internal law. And we've seen that happen here in the United States. Just to give you an example, when the WTO was created in 1995, we had in the United States domestic law 17 years of protection for a patent. WTO law requires 20 years of protection. So US law was 17 years. WTO rules required all member states in the WTO to provide 20 years of protection. So we had to change our domestic law to match. And that's sort of a general theme over and over. There's a term for that called harmonization, which I'll get to in a little bit. But this is the idea that an international treaty, as applied domestically, will override a lower level law within that country. Now there are some times it happens automatically and other times not, but I just want to introduce this concept because we're going to see this same theme over and over again. So we've also had this in WTO rules where we've had to change some of our environmental laws to match WTO rules, etc. This also means that if we have a treaty, a court here in the United States, if a treaty is applicable to a lawsuit domestically, if it's relevant to that lawsuit, then a judge here in the United States must apply that treaty basically domestically. So this essentially enacts, in a way, international law potentially domestically, even if they're in conflict with each other. Now, when this was written, hundreds of years ago, wasn't as much international law. Now we have a lot of international law, and so now we're starting to see where this comes into play a lot more often in the real world. So next slide down, I want to talk about this for a moment because this is very important. All right. I'm just going to switch this because I want to fool around with it. All right, so within the United States, all international law must be made at the federal government level by the President. The President of the United States has the authority to enter into international law, be it treaties, conventions, other types of international lawmaking activity. A state cannot enter into a treaty or other type of international law. So when I talk about a state domestically, the state of Oregon or California or whatever, the states do not have, under the US Constitution, the ability to enter into international law. Only the federal government may do so. And that's typically going to be a similar type of rule in international law as a whole. In fact, later on we're going to look at in various different treaties, it specifically states that in a federal form of government, that's what we are, a federal form of government, whereby you have a federal government which is like an umbrella that covers all the lower level political units within that country. Of course, we have the 50 states of the Union. Each state has its own ability to make law within that state, but they cannot make law internationally. So the federal form of government in international law is the federal government itself. Now there may be exceptions to that here and there, but it would have to be agreed to by the federal government. So in the US, only the federal government, that is the government of the United States of America through the president, can make international law. If a state enters into a treaty, it's invalid, basically. The president has the authority to conclude treaties, that is, make treaties. Now, that's not usually done directly by the president. That's usually delegated either to an ambassador or the Secretary of State within our domestic system. Other countries have the same basic idea, where it's usually delegated to whatever their diplomatic procedures are within that state. This is sometimes an issue when you're talking about treaty law, is if you have a number, maybe we have 50 countries trying to put together a treaty, and as part of that, it's not clear who has authority in each country to make the treaty. Well, that will depend on domestic law. And we'll look at that more in the Vienna Convention on Thursday, I think. In the US, all treaties must be approved by the Senate. So if the president enters into a treaty, it must go to the Senate for approval. If the Senate does not approve the treaty, sometimes that's called ratification. If the Senate does not ratify the treaty, then the treaty is not binding, does not bind the United States domestically. And I'm going to say that with kind of some quotes here, because in reality, even if the Senate does not approve a treaty, the U.S. may still have to follow the basic idea of a treaty under what's called customary international law, which we'll talk more about in a little bit. But technically speaking, the president can enter into a treaty, and then the Senate must approve the treaty. Now, it's not common, but it does happen where the Senate will not approve a treaty for various reasons. And that may happen, it may occur over decades. One example is we have the United Nations Convention on the Law of the Sea, which is the United Nations basically large-scale treaty about the oceans. And that includes maritime law in terms of navigation, but it also includes rules about mining the ocean floor. It's called deep seabed mining, or oil drilling offshore. And there are parts of the United Nations Convention that have never been ratified by the United States Senate. Now, we still follow a lot of the rules within that treaty, or the convention, I should say, just as a matter of customary law. But the rest of the convention we don't follow, and other countries don't either, because there are disputes about how it's structured. So technically, the president can enter into a treaty, the Senate must ratify it. However, in the real world, there are times when it's not ratified, but we still follow the international law. I know you're going to be confused by that, and it is confusing, but I'll explain more why when we get to customary rules of international law. Now, why do we have this idea that the Senate must approve a treaty? Separation of powers. That's the concept whereby we, in our domestic U.S. law, have three branches of government: the legislative, the executive, and the judicial. And the idea that there'll be a check and a balance built in. And the idea here is that requiring approval of the Senate is a potential check on the power of the president. Because theoretically, under the Supremacy Clause, which makes treaties a higher level law over state law, then theoretically, if we didn't have this approval, then the president could essentially change the law internally in the US by entering into a treaty. So in essence, the president could legislate. And that was recognized when the Constitution was written, and so that was put in there with the idea that we don't want to have that much authority within the office of the president. There needs to be a balance that goes on by having Senate approval. So keep that in mind, and I'll bring that up a couple times more as we work our way through the class. All right, let's go on to the next slide. I just want to talk about comparative law a little bit. Whoops. All right. Comparative law. So comparative law is a term that's used both internationally and domestically, but we're talking about internationally, of course. And this is the idea of what are the historical origins of the law within a particular country, from a historical standpoint. And basically, what this boils down to is over hundreds and thousands of years, there have developed various systems which are sort of the primary systems or families, or however you want to phrase it, of the origins of domestic law within a country. And so really it breaks down to three different broad, and we're talking very broad-based systems here. And if you look at the slide I've got up over there, we have civil law. Let me put it up on this screen here too. So civil law, common law, customary law, Islamic law, and then mixed systems. So basically, what this boils down to is the idea that over time, the laws domestically have roots in these various different families of law. So if you look around the world, you'll see civil law are the countries in red or have some red involved within them. Common law, blue, and then we have the other families which can sometimes override. Now where does this come from? Well, common law primarily derives from law that was English law based. And then as there were colonies, etc., the law of England, English common law, was applied in the English colonies. English common law was based primarily on the concept of general principles and rules that were not very detailed. So a general rule of law, and then they would be applied by a court in a given circumstance. So I'll give you an example of a common law rule that we still use here in the United States all the time. It's called the reasonable person test. Have you ever heard of that before? Reasonable person test? If you've ever been pulled over by a police officer for speeding, we have a rule called the basic rule. Officer may have told you that. You're violating the basic rule. That's based on the reasonable person test, that you have an obligation as a person to act reasonably under the circumstances that existed at the time of the situation that's involved. So for example, if I'm driving down the road in an ice storm and there's 6 inches of snow and ice on the ground and it's snowing hard and even if I'm going 55 miles an hour, which is the speed limit on the highway, if there's that much snow and ice and a bunch of other cars that are all stalled, it's not reasonable for me to drive that fast, even though the speed limit is 55. So even though I'm following the speed limit, I'm violating the reasonable person test or the basic rule. And so a court would find me liable if I got into a wreck and hurt somebody for violating that basic rule. So that's a common law principle. So general principles of law. And we see that still today. We see that, as I'll talk more about in a minute here, the idea of acting in good faith is a common law rule when you talk about a contract. So common law-based countries are essentially have historical roots going back to English law. Civil law-based countries are based primarily on the laws that came from continental Europe, which may be Spain or Italy, what is now Italy, Napoleonic law, which is French law, German code from Germany, what we now know as Germany, and civil law-based systems, again, if you look around the world, are going to have roots that tie back to continental European countries. Now, civil law and common law are kind of two different basic theories of law. Common law is more of the idea of the reasonable person. Civil law is much more detailed, and it's usually going to be based more on very detailed written law. And again, some of that goes back to the Roman Empire, Lex Mercatoria, and that sort of thing, merchant's law. So civil law was much more what we call codified, written down into very precise rules. And the idea was it was much more specific and also much more rigid, if you will. Common law was more generalized principles that would be applied depending on the circumstance. And so historically, that's where we see these families of law. And then of course we have Islamic law, which are based on Sharia. And then we have other systems which are based upon cultures in the area. But that's what you still see kind of from a historical standpoint. One of the things we're going to talk about, again back to this whole theme of the change in law over time, is we're starting to see where these systems are kind of merging as we have more and more international treaties and conventions involving more and more large groups of countries, where a lot of these historical families of law really, the lines are becoming very blurred and really becoming in a way irrelevant as we start to see more and more harmonization of law around the world through organizations. And that's going to be one of the themes that we're going to talk about when we get into organizations like the UN, et cetera, is how one of the fundamental ideas of international organizations is let's try to have countries make their laws more or less the same involving certain things like international trade, international human rights, and have their domestic laws brought into harmony with each other. And that's the actual term we'll talk about in a moment. That's one of the goals of the UN, actually. I'll show you when we get to the UN Charter in a week or so, next week. One of the goals of the UN is to try to arrive at this harmonization of law. Okay, enough on that. Let's move on here, because I want to get to Article 38. All right, so page 19. I got to get switched around here on my PowerPoints. Okay, so let's move on to sources of international law and get to Article 38 of the International Court of Justice. So historically, as we've talked about, I want to back up. I'm going to give you a question I don't know the answer to this question. This is more of a rhetorical question, and it's debatable depending on who you ask. But here's the question. This is also probably going to be an essay question. What is the most important source of international law? What is the most important source of international law? And there are two answers to that question. One is from a historical standpoint, and then two, more modern. But what I would say is the most important source of international law is what we call custom. Customary international law. That historically has really been the driver, the primary source of international law historically. And what I mean by custom is, what do countries actually do? Kind of like the old saying, actions speak louder than words. What does somebody do versus what do they say? So that's the sort of idea of what is custom. Custom is what actually happens in the real world. That's the example I give you of the coral reef, the example of two ships coming head on to each other, they both turn right, a 3-mile limit because that's how far a cannon could shoot, basic, real world stuff. So from a historical standpoint, I would say that custom really was the primary, most important source of international law. And it still is true today in many respects, as you'll see. The next source, of course, are agreements of sovereigns. So agreements over time change, although nowadays agreements of sovereigns probably are number one rather than custom. And I'll show you what I mean in a moment. And then historically of conquest, city-states, use of force versus force of law, merchants' law, etc. We've talked all about that. So back to my question. What's the most important source of law? Answer, one of two things. It's either going to be custom or agreement of sovereigns. Now, we don't really say agreement of sovereigns anymore. Now, we use the phrase treaties and conventions. So, when we talk about sources of law on an international level, we're talking about, well, just to put it in context, if we're in an international court, let's say there's a dispute between two countries or a whole group of countries, doesn't really matter. What is, or where are the judges in that court? We're talking international court now, not a domestic court. What law do the judges apply to that particular case? So let's say we have two countries that are disputing over fishing rights off an island that is right on the border between the two countries. And they go to the International Court of Justice rather than fight it out like historically they would have done. So what law does the International Court apply? Do they apply the law of country A? Do they apply the law of country B? And historically, if country A was a common law country and country B was a civil law-based country, they may have very different rules. Same thing in international contract law. Common law rules in contract law are very different from civil law-based country contract law. So how does a court in an international dispute know what law to apply? And the outcomes may be vastly different if you apply the law of England versus the law of France, or the historical roots, right? So now, essentially what an international tribunal, it may be the International Court of Justice, or it may be an international arbitration court, whatever, this is pretty much the order that the courts will look at when there is a dispute between two or more countries. So first thing, the court is going to look to see, all right, are there agreements in the terms of a treaty or a convention that both countries are part of that tell the countries what the rules are going to be in that type of a case. And if that's the situation, if both countries have agreed to a treaty or a convention, which is a large-scale treaty, then the court will apply the treaty or the convention as the source of law. And that makes sense, right? The countries have agreed to the treaty. The treaty may be different from their domestic law. Now we know under the Supremacy Clause, that would trickle on down. So the idea then is that international court, quite simple, very logical if you think about it. Two countries, or more than two countries, whatever, have agreed to this treaty. Therefore, they both agreed that they'll be bound by the treaty. And therefore, they've agreed that this treaty will control any dispute that arises out of the treaty. That makes perfect sense. In fact, that's the whole idea of treaty law, is to get countries to agree to the rules, hopefully before there's a dispute, right? So that's nowadays the primary source of international law, treaties and conventions. Next, we have what's called customary law. Again, this is what countries actually do, customary rules, and we're going to get more into that in a moment in detail. And then number three, what if there's no treaty? What if there's no customary rule that countries have practiced over time? Then the court is going to look at what are general principles of law that are common to both countries or a group of countries that are involved in the dispute. Now, what does that mean? So a general principle of law would be something like the right to a jury trial, the right to confront witnesses that are accusing you in open court, the right to be represented by an attorney if you're accused of a crime. The idea of the reasonable person test is a general principle of law. The idea that a contract, if you enter into it, is to be strictly construed based upon the written terms, and that you have a good faith obligation to follow the contract. So these are just general ideas. So let me give you an example. Let's say we have a dispute. I'm going to go back to my ship that got seized between two countries, and the dispute is about whether or not the country that arrested the sailors on that ship has an obligation to give the sailors a jury trial and to give them an attorney and to allow them to confront witnesses in court. And if both countries domestically have those rules that apply to their own people, then a court internationally is going to apply those rules in the international dispute, because each country has those basically same rules domestically. Does that make sense? So if I'm a country saying, all right, I seized sailors from the ship, I'm not going to give them a jury trial, but domestically we have that law in our country, even though I'm saying I'm not going to apply it here, that kind of violates our own general principle of law. So basically the courts are going to look to see, are there rules that both domestic law that they share, and if so, then those will be applied by a judge internationally. So you start here. If that doesn't apply, then you go to customary. If that doesn't apply, then you're going to look at the law of the states that are involved and see where their own laws overlap with each other. If that doesn't work, next you would go to judicial decisions that are court decisions within the countries. And so if both countries that are in dispute have internal court decisions, like from the U.S. Supreme Court, for example, or the equivalent of the U.S. Supreme Court in another country, and those court decisions kind of match up with each other, then an international court will basically follow the domestic court. And if none of those apply, then you're going to look at, okay, what are some academic principles, judicial scholars, international lawyers, international writings, that kind of thing. That's kind of last resort. So that's the general order of things. Now, I want to show you this next slide. Now I'm going to go back to my, oh, come on. This is on page 20. Okay, this is a cut and paste. Literally, I cut and pasted. I'll show you from page 144. This is Article 38 of the Statute of the International Court of Justice. First of all, what is the International Court of Justice? The International Court of Justice, I will abbreviate, and I apologize for my bad handwriting, ICJ, the International Court of Justice. So I'll say ICJ over and over again. I'll say Article 38 over and over again. So the International Court of Justice, Article 38, comes from the statute that establishes the International Court of Justice. The International Court of Justice is basically the Supreme Court of the United Nations, if you want to make a comparison. It is the, I don't know, I'm not sure highest international court is the right way to phrase it because, but in some ways that's true. It's kind of like the Supreme Court of the world, sort of. So the International Court of Justice is the judicial branch of the United Nations. And their job is essentially to decide, to put it just in plain language, lawsuits between United Nations member countries and potentially non-UN member countries as well. We'll look at it more in detail later on when we get to the UN. But for today, I want you to take away a couple different things. Number one, the International Court of Justice is the judicial branch of the United Nations. And the reason this is important is as part of the creation of the United Nations to begin with, the United Nations Charter, and any countries that joined on to the UN later on, the original countries and then all those that joined on later, as part of that, as part of becoming part of the UN, countries have to agree to follow the decisions of the International Court of Justice. There are some exceptions to that. But for the most part, that's part of an obligation of being a UN member, that you agree as a country to follow these court decisions that are issued by the International Court of Justice. Now again, this goes back to this same theme I keep going back to over and over. Rule of force versus rule of law. Rule of law, one of the components of that is putting judicial court systems in place to hopefully solve disputes without resorting to force. Now sometimes force is necessary, but this is the first manifestation of that. That is to have a United Nations court where countries can go file lawsuits against each other in the court and hopefully have the court decide the case by judges' decisions rather than military or economic force. Now, with that background, again, the idea is this is the United Nations Court. UN member countries have agreed automatically to be bound by it as being a UN member. And so this tells us, in order of authority, when there is a dispute among countries in front of the International Court of Justice, this is the list of law that the court will apply. So first of all, international conventions, whether general or particular, establishing rules expressly recognized by the contesting states. In plain language, treaty law, right? So back to the idea, if we have a case in front of the International Court of Justice, the member states have agreed to the jurisdiction of the court, the authority of the court, and also they've agreed to apply this order of law internationally between them.